So just one part was remaining for agency, and we'll
Yeah.
complete that one. Okay. I saw a few questions also from previous year question papers. These things
Okay.
were asked. Basically, one additional thing was there, which also I have added here. Okay.
Okay.
So regarding termination of agency, we are left with another question was with regard to sub-agent, and yeah, I think that's all. Okay, and one more, I guess. So we'll see that part. So last
Okay.
class we saw regarding this, right? Creation of agency. Then there were this few ways of creating it. So you can explain on any of those points, right? That this is how
Yes.
it might be created, ratification and all that stuff. So with
Yeah.
regard to termination also, it's more or less similar, only that we have few points or few ways by which it may be terminated. Okay, so termination of agency, what is it? That we are putting an end to this contract that is there between these two parties, where one person was acting as an agent or a representative of the other person. So termination of agency, we have provisions under sections 201 to 210 of Indian Contract Act as well. So you can mention these sections also, and you can give a basic intro on what termination is and why is it important. That if agency is created, it's not like for their entire lifetime they are going to continue. Sometimes their need or purpose may end at an initial stage also, right? So they should be having this option of putting an end to this agency relationship. How it can be terminated? There are basically two ways by which it may be terminated. Under both these ways, we have few different provisions. Okay, like we have by act of parties, that either agent or principal is doing something, and by their act or conduct they are putting an end to the agency. That is nothing but act of parties. And another one is by operation of law. That means there may be some provisions in the agreement itself, or there might be some law which is being applied to them. As a result of it, there is an end that is there to the agency relationship. Okay, so by operation of law, it may mean there is some provision in the agreement, and because of that specific provision or clause, it is getting terminated. Like agreement also is like law only, right? When I agree to do something, it becomes like a law, it becomes binding on me. So if there is a clause based on that it is getting terminated, we would say that it is by operation of law. Why? Because that specific provision of the agreement is applicable on me just like any other laws would be. So these are the two ways we have: by act of parties or by operation of law. When we say act of parties, we know there are two parties in an agency relationship, obviously principal and agent. So what can be the act of parties? It may be by mutual agreement. That means both the principal as well as the agent wants to put an end to the contract, right? So it might be by mutual agreement. Both of them want to put an end to the contract. Accordingly, they will do it. That is coming under act of parties, that they are doing something. As a result, this contract is getting terminated. All right. First is
Mm-hmm.
mutual agreement. Second one is when agent's authority is revoked by principal. Obviously, when discussing rights and duties, we have seen that principal would delegate some authority to the agent, and agent is supposed to act accordingly, right? But principal is having this option of revoking authority. If principal revokes or takes back the authority given to the principal, that would also lead to termination of the contract. That means here it is done by principal because of some act of principal, that is revocation of authority, there is termination of contract. Similarly, when agent renounces the business of agency, that means agent himself is saying that I want to like put an end to this, I don't want to act as an agent anymore, I want to separate myself from it. that also may lead to termination of agency. So when we say act of parties, it may be because of an act of principal, because of an act of agent, or it might be a mutual agreement between the two persons. So we basically have three things, and this is like you can remember also, right? There are two parties. It might be because of principal, agent, or because of both of them. That is mutual agreement. This is revocation of authority by principal, and this is renunciation of business by the agent. So these three we have under by act of parties. Then next one we have is by operation of law. That means some law which is applicable to the parties is being applied here, or because of any provision in the agreement, the agency relationship is being terminated. Now, first one we know, right, that agency might be for a specific task also, right? Like auction and all, you need to sell this horse. For that, there is an agency relationship. Once this task is being completed, definitely agency is going to come to an end, right? So it might be terminated when business of agency is completed. If it was only for one specific business, like that of auction, selling something, once the purpose is being done, it would come to an end, right? Someone may appoint a broker as an agent to find a buyer for, like he wants to sell a house, he may appoint a broker, right? That you need to look for a buyer. Once he gets a buyer, the deal is finalized, sale is done, it again would come to an end, right? So this is when business is completed, this provision would be mentioned in the agreement itself that we are going to put an end to this relation once this purpose is completed, the business is done. So this and the second one are similar by expiry of fixed period of term. If the term was fixed that we are acting as an agent and principal only for 2 years or might be 3 years. Once this term is being completed, again, agency also would come to an end unless and until they have renewed it. Like in the agreement, they may have a provision that initial validity of this agreement is going to be 2 years, but there is a provision to renew it or extending its validity, right? There might be a provision or there may not be. It's not like necessary. So if they have not renewed it, there was no such provision. Once this fixed period is over, then also agreement would come to an end, agency will be terminated. So these two are kind of similar. Here business is done, here term is over. There was one case with regard to this one of expiry of fixed period. So what happened here basically is that there was an agreement between two persons with regard to running a petrol pump for a specified period. So when they entered into this agency relationship, time frame was specified during which this petrol pump business will be run by them. It was held that agent was bound to vacate the premises on expiry of period. There was no renewal clause, nor in fact there was any renewal. So if you do not have any renewal clause and you have not renewed the agreement, then it indicates that your contract will come to an end once this period is over. If you have got a renewal provision, might be they would say that once agreement is coming to an end, just like before 1 month they would give a notice to get the formalities done. Might be we would extend 1 more month, like that there might be provisions. If there is no provision as such, once the time frame is over, and if it is not being renewed, we would assume that this agency has come to an end. Okay, so these two are based on whatever is mentioned in the agreement, right? Based on that, it is being terminated. This is clear, right?
Yes, madam. And probably a common sense which can be applied and based on
common sense things only. Like from the name also, it's very clear that, okay, fine, operation of law. So there is some issue with regard to this numbering thing. See, I don't know why.
Sorry, what happened?
Like this numbering, right? Some issue is there.
Okay.
But C again, C is coming.
Actually, it is taking the different series. That is the reason.
Yeah, that's right.
So,
I added this case from somewhere, no? So that's the issue, I guess. Okay. So that those two things are there. Whatever is mentioned in the agreement, based on that we have these provisions. Then when either of the parties dies or becomes mentally disabled, like in while discussing about the this right eligibility of parties who all are competent to contract or who all are competent to appoint an agent or be a principal, we have seen that parties should be mentally sound, and obviously parties should be alive to perform their rights and duties. So that again is like a common sense thing. If parties only die, if agent is not alive, if principal is not alive, then there is no question with regard to it, right? That the agency would continue. Same would happen with regard to they being becoming insane at a later stage. So if any of these two things happen, then also it would lead to termination of the agency or termination of the contract. Then when principal is adjudicated as an insolvent, if he is declared as an insolvent, then also he is not entitled to have an agent, because he will have to pay the agent, right, for whatever services he is providing. So if he himself is being declared as an insolvent, then also this agency would come to an end, it will be terminated. Then we have destruction of subject matter. So basically there would be some purpose why they have entered into the contract. If contract was because one person wanted to sell a horse, right? Might be he appointed an auctioneer as an agent, and I want to sell this horse and you need to help me out with that. If horse only dies, that means destruction of subject matter. For whatever purpose you had entered into the agency, that matter itself is no more existing. Horse only died, that also would lead to termination of the agency relation, right? Because it would again have no meaning continuing with that relation. Dissolution of company. There might be some, like firms or companies which may be regarded as principal in the contract of an agency. That sometimes it might not be one, like one individual, but rather it may be one company or one firm. Like it may be LIC, right? So if LIC is the principal and LIC itself is dissolved, right? LIC itself is no more existing, then what will all those agents do? It's of no use, right? So if that entity only is dissolved, then that also would lead to termination of all these agency agreements that were there, right? Because agents would have no purpose after that, after dissolution of the company. So all these 1, 2, 3, 4, 5, 6, all these 6 ways are coming under by operation of law, and for act of parties we have basically 3. So 3 for this, 6 for this one, right? Here we have a combination of like general provisions as well as what is mentioned in the agreement, right? So based on that, it will be accordingly decided whether it is putting an end to the agency relation or not. Then there is one more thing which you can include in your answer. Like this one is a common question that they are asking basically. You can include this also, like time from which termination of agent's authority becomes effective. Okay, fine. We know that there is this provision of terminating the contract, but then from when it becomes effective, right? So with regard to that, we have these 2 provisions. You can mention that termination of agency does not become effective immediately. It would take effect against the agent when the fact of termination becomes known to him, and against third persons when they come to know about the same. Like when third parties come to know about it, might be they would publish something on a newspaper or their website or something like that. Like basically they are making it public that we are putting an end to this agency relation and all that stuff, and accordingly it will be terminated, right? It would depend on situation also, what kind of contract was there between the parties, whether they were contracting with too many third parties or not, like whether is it needed that they disclose it to public or not. That would also depend on the kind of contract that was there between them, right? If someone is hiring a broker that you find tenants for my house, in that case if there is termination of the like agency relation, obviously landlord is not going to publish an ad somewhere and make it public, right? That there is no need in such a case. So these things also you can mention. Like I guess there was one question with regard to what are the ways by which an agency may be terminated, and a short note was there. So this is clear, right?
Yes, madam.
Yeah. So you can also mention what agency is, why is it created, why is it becoming so popular. After that, what is termination? Then we have these two different ways of terminating. Under that, we have 9 different ways by which it may be terminated, and accordingly, one conclusion you may give.